What's up, everybody? Hey, this your boy C has Motivated Minds. So let's just get straight to this. I see that the internet is on fire right now with the verdict in the Kyle Rittenhouse case. And a lot of people don't think that it was right. That the kid got found not guilty on all charges. And if you sit and if you look at the case, there is really a lot to break down. And I think that people who are just talking, just the average citizen, that's partaking in what we call barbershop talk, they just talking without really dissecting and looking at the case. And when you sit down and if you look at a lot of the decisions that were made and you really peel the onion back and look into this case, there is a lot to dissect. If you start to look at some of the laws, you can see how he got off, and you'll also understand that when it comes down to, let's just say, a minor, because he was 17 at the time, in possession of a firearm, the judge threw that charge out. But if you look at why he threw it out and what the defense actually did, then I think you'll understand. So let me just start by saying that, I'm not an expert on the law. I'm really not. I can read, and I can kind of do some research and interpret some things, but by no means am I an expert. What really got me into looking at the laws and somewhat understanding was back in 2012. That was right around the time that Trayvon Martin got killed. So at first, I felt like, everybody else really, just looking at the case, I felt like, man, how could he do that to that kid and he should be found guilty? But, as I progressed, the one thing that I was really good about was case law. Well, it was laws. So where everybody else in the class, was just, you would hear a case of like Miranda versus Arizona or Garner versus Tennessee. They just kind of skimmed over the cases and understood that one dealt with Fifth Amendment rights, and like Garner versus Tennessee dealt with like the fleeing felon. What I did, unlike most people, was I sat down and I started researching the cases so that I could get a full understanding. So it was a lot of stuff like that, Matt versus Ohio, and it was so many others. So when they were discussing how a lot of these laws came about, just like with the Miranda rights that came about because of Miranda versus Arizona. So they would just skim the surface. I could sit and what I did was, and I'm not tooting my own horn, I'm just giving y'all some background. What I ended up doing was I could go in and articulate the who's, what, when's, where, the whys, and the hows, because I spent a lot of time, looking at the ins and outs of the case. So, that's how, my interest in that came about. And I started to see things in a different light. And I really started understanding how, when some of these cases with police officers and how they got off, because I really got into reading the laws. So I'm telling y'all, man, this is another case where you have to understand the laws and the way that the laws are written to understand why this kid got off. Now we can all get into the white privilege and the racism and all that stuff, but it all starts with the laws. I'm just really curious, how many people have went in and researched and just actually looked up the law? Let's just say in Wisconsin, since we talking about this case. So what you have right here is the law, the Wisconsin self-defense law. So if you notice, there's a couple things in there that I highlight, but it just starts off, and I'm not going to read this whole thing, but it starts off saying a person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what a person reasonably believes. Now, number one, you're privileged to threaten. I mean, you have, according to the law, you can either threaten or you can use force if you reasonably believe, right? So when you see a lot of self-defense laws, or even stand your ground laws, because they're a little bit different, you gonna see this word right here, that reasonably believe word, a whole lot. I always stop at reasonable belief, because a lot of people don't understand what reasonable belief is. But the definition of reasonable belief is basically is a belief that will be held by just an ordinary person who was in the exact same situation. And the problem that I find is that a lot of people skip right over words, but when it comes down to the laws and in the courts, these things have meaning. And let's say we understand that. But if you look through this, and I want y'all to read through, because you see the term reasonably believes several times in here. But if you look at this line where it says that the actor may not intentionally use force, which is intended or likely to cause death or great bodily harm, unless, and I stress the unless, the actor, there it is again, reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. Now, here's another thing that I always talk about, that imminent death, right? But a lot of people fail to look at that great bodily harm. So I can also use, in Wisconsin and many other states, but we're talking about Wisconsin right now, I can also use deadly force, not only if I believe that this force is going to prevent imminent death, but if it's going to prevent me from getting seriously hurt, then guess what? I can use deadly force, or threaten to use deadly force. So basically what we have here is, if under the law, you can use deadly force. Basically, if just the average person who was in this same situation believes that they were in fear for imminent death or great bodily harm. And that's why oftentimes you hear police officers say, I was in fear for my life, right? Because that's where that comes in, that imminent death or great bodily harm. So that's part of how this kid got off. So that's the Wisconsin self-defense law. But I want to show y'all something else, because everyone's talking about the gun charge that was dropped, and everybody's talking about this gun charge, but they don't actually know what the charge was and what the penalty of that particular charge was either. So let me show y'all something real quick. What I want y'all to see is the charge, because everybody keeps saying, well, the judge dropped the charge. So the charge is possession of a dangerous weapon by a person under the age of 18. And y'all can read this right here. Under Wisconsin law, any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a what? Class A misdemeanor. Now, within the law, it lines out what a dangerous weapon is. I'm telling y'all, go look it up and you'll see, it has it all, what is considered a dangerous weapon. So even if the judge wouldn't have dropped the charge and he would have been found not guilty of all of those other charges, but they would have found him guilty of this charge, right? This gun charge it's only a class A misdemeanor. But y'all see that little sub paragraph B right there, where it says except for provided under paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under the age of 18 years of age is guilty of a class 1 felony. So this is the stuff that I keep talking about. Nobody is addressing the issue of the adult who gave a minor an assault weapon. Now that paragraph C, if you go look it up, it should talk about what I'm getting at is, I've read a lot of comments and people keep talking about, well, he dropped the gun charge, and people never took the time to go look up what the gun charge was and what it read. So again, even if he was charged with this, it was only going to be a misdemeanor. Did y'all know that when this first came up about possession of a dangerous weapon, by a person under the age of 18, when it first came up, did y'all know that the judge said that he wasn't going to throw the charge out, is what he said. But he said, he would reconsider it later. But right before it went to before the trial, before the jury, came in, the judge actually he threw the charge out, because what happened was the defense found a loophole. And basically what the loophole says is that the misdemeanor only applies to 17-year-olds carrying short barrel weapons. And carrying short barrel weapons at any age in Wisconsin is a felony, with the exception for active military and police officers. So due to the fact that he had an AR-15, which is not a short barrel weapon, the defense argued that this law did not apply. So what did the judge do? He came back and he agreed, so he threw that charge out. So check this out. Where the language in that law basically comes from was it was a bill that was introduced by then Republican governor by the name of Tommy Thompson, which was signed in 1991. And lawmakers across the country were trying to find a way to curb gang violence during that time. We talking about the 90s, and we in that whole crack era and all that stuff. So one of the defense attorneys in Kenosha said that the law was likely intended to prevent young people from carrying sawed-off shotguns. So understand this. So they took a law that was intended to stop Ray Ray and Pookie and them from killing each other, and they used this law to get this charge on this kid dropped. Imagine that. So basically, that's how the kid got off. They dropped all the charges. I mean, they used the law. And we know, man, that the law is not fair. I keep saying, I've said it a million times, that what we may feel is morally right may not be legally right. And again, we know that the laws are not fair. But I want to get off that for a minute, because there's a lot of things that's been lost in this case. Like, these folks raised $2 million to bond this kid out of jail. $2 million. Now think about this for a minute. Now, had that been little Mook them, mama and them would have been selling, grandmama and them, my auntie and them would have been selling fish plates and all kinds of stuff, and them jokers would have been sitting right there. Half them mugs can't get bonded out on a $1,500 bond, and we talking about these folks raised over $2 million to bond this kid out. Now think about that for a minute. Then I want y'all to think about, and I know that I've said this a lot, that the two cases have nothing really to do with each other. You have all these preachers right now that is in Brunswick for that trial and the folks that killed Ahmaud Arbery. If this was a black kid in the exact same situation, how much money would all those pastors that's sitting in Brunswick right now would have raised for that kid's defense? Hold on, I'm gonna wait. Because like I said, Ray Ray and Mook and them sit in jail waiting to go to trial or take a plea and end up with a public defender over a $1,500 or a $2,000 bond. Yet these jokers sitting in the court and want to support this family down in Brunswick. And I know these two cases don't have anything to do with each other, but I'm just saying, oftentimes they can grandstand when they want to grandstand. And I'm not attacking these pastors, but I'm just saying they can grandstand and show up when they want to show up. But sometimes when cases are really important and they really need it, these jokers ain't nowhere to be found. Another thing I want to point out about, those pastors being down there in Brunswick. Now, they had one of the attorneys stand up in court and said that he didn't want any more black pastors to show up or sit in the courtroom because of, it was intimidating. But yet, and there were a lot of people that agreed, but yet no one has an issue when there is a protest over a civil rights issue, or when an unarmed whoever, gets shot, and you have people show up armed in full body armor. I'm talking everyday citizen They don't see nothing wrong with that though. But yet these pastors down there who don't do anything but pimp people. I mean, I'm sorry, who don't do nothing but preach the gospel. That ain't doing no harm to anybody. They see them oftentimes as a threat, but they don't see these folks that show up at these different rallies and they're fully armed. They don't see them as a threat. I didn't see a whole lot of people talking about when them folks stormed the Capitol and they had cruel intentions. They make every excuse in the book for them, but yet they want to talk about some black pastors sitting in a courtroom with a family, whose child had just got murdered by 3 grown men. Come on, man. So you got a lot of people who are upset that this kid got off. And I'm telling y'all, this case, it really don't pertain. If y'all know what I mean. It really doesn't. But if you want to be upset about something, be upset at the laws. Be upset at the way these laws are written and the way that oftentimes these defense attorneys, depending on who's on trial, the way that they twist the laws, that's what we should be upset about. Not the fact that the kid got off, because we know that if that was little mook mook them, they'd have hit him with the bench, like I said with in another video. Because first of all, the Joker probably would have had a public defender, not somebody raising $2 million to bond them out, and then even more money to provide defense for them, right? And a lot of people talk about Ben Crump, but let's not forget, Ben Crump is a civil rights attorney. He's not a criminal attorney. So that's what y'all should be mad about, the laws. And what needs to happen in this country is that the laws need to change. Let me ask y'all a question. How do you fight against a system, or how do you win against a system that was set up and designed for you to fail? How? The way that some of these laws are written and how they always find a loophole. How do you really fight against that? A lot of people are mad because, or upset because this kid got off, and I get it. Because we all know that if that was my son or one of my sons or somebody who looked like them, it wouldn't even been a case. He wouldn't have got everything that this kid got, starting with the attorneys. Well, I don't know, because, anyway, for the most part, starting with the attorneys, because they more than likely, kids like us, oftentimes, they would have had a public defender. So how do you fight against a system that was set up and designed for you to fail? And let me put this in y'all minds for a second. You got people out there that's worried about young Dolph. Now I ain't speaking negatively on that, because I don't do that. But what I'm saying is, that was somebody who was in that lifestyle. And if you listen to the music, that's what he talked about. Or, you got people out there and I'm gonna go here for a second. You got people out there still worried about George Floyd. George Floyd committed a crime, and I'm not saying that he deserved to die, because he didn't, right? And I'm not saying that police officer was right, but you got people worried about George Floyd. But ain't nobody worried about Tamir Rice. We ain't talking about Tamir Rice anymore, right? Or I'm gonna tell y'all something nobody's talking about. What about that 9-year-old girl in Philly that got caught up in a gunfight between 2 juveniles that decided to have a shootout at a football game? And then when the police came, they started shooting. And this little girl ended up getting shot. And when the ballistics came back, it came back that she was shot by the police. But y'all ain't talking about that, right? So my question is, in case ain't nobody worried about, and this happened over a month ago, but ain't nobody talking about that. So my question is, and I know I don't got off, I have, but I got to say this. So my question is, where's all these jokers that y'all champion and some of y'all champion as heroes? Where's Sean King at when in a case like this? Because normally he'll be all over that. Where's Dr. Umar Johnson at? Al ain't showed up to that. Jesse ain't showed up to that. I ain't seen Ben Crump on that. Where they at? Ain't nobody worrying about stuff like that though. One more thing that I want to say about this, and I'm gonna be done with it, is well, actually two more things. One, everybody's talking about how this kid went from Illinois to Wisconsin, how he crossed state lines. But did anybody bother to look to see how far he actually had to drive? You know, a lot of people are making it seem like that kid drove 2 hours to get to where he was going. Man, he only drove like 30 minutes. But I mean, that does not negate, you know what I'm saying, what happened. It really doesn't. But I'm just saying. The other thing is that kid went with some grown folks because they felt the need to go protect somebody else's property. Right? What happened in Brunswick? The people there felt that it was their right to go and protect somebody else's property. And you know, this seems to be a common theme, that them folk always feel like it's their right to go get in somebody else's business. Now, I understand, you know, the neighborhood watch, you know, because back when I was growing up, I had a neighbor named Miss Powers, and Miss Powers was, you know, she was the neighborhood watch before neighborhood watch. But what she would do is, if we were doing something, she watched everything in the neighborhood. You know what she would do? She would tell. And I believe that if she was alive today and stuff was going on, not only would she would tell, but she would call the police. But these folks are taking it upon themselves to be the police. Why do they always feel like it is their duty to go and do that when it's not? So you gonna go grab a firearm, an AR-15, to go across the state line, even though it was only 30 minutes away, to go protect somebody's property that's not yours? Come on, man. And this is what I'm saying. The laws in this country need to change. And we need to keep fighting for that. And I ain't talking about marching and singing and heeing and hawing and wearing out some church shoes. But we need to, you know, get up in the, honestly, if y'all really want to know, we need to do like them folk with money do and pay some of these lobbyists to go before Congress, right? Or go down to the Capitol buildings in the state, because that's what the lobbyists do, and that's what the folks with money do. They pay these lobbyists and they go stand before Congress and all that stuff, right? But you know what that means? That means that we got to stop buying Jordans and stop buying these LeBrons and get our paper right in order to get some representation to go and do that. You know, Nino Brown said, money talks, BS runs a marathon. Get your money up. That's what we got to do. We got to get our money up. You know what I'm saying? To get some people to go speak before those people who, the lawmakers, is what I'm getting at. Anyway, I don't know how long this is by the time I put this together, but, you know, I just kind of wanted to get into a little bit of the case and just talk about a couple other things. But, hey, this your boy CS Motivated Minds. I just want y'all to think about it.